Hi, everyone. Welcome to our event. My name is Rob Crawford, and I facilitate the Washington State Religious Campaign Against Torture, which is the principal organizer of tonight's event and sponsor. I'm also a professor emeritus at the University of Washington, Tacoma, and involved with the Center for Human Rights. So the Washington State Religious Campaign Against Torture was founded in 2007. We are a nonpartisan interfaith organization, but also for people, including people who are unaffiliated with any faith tradition. We've been very active in the Seattle area for the 10 years that we've been around, presenting educational events and various actions around the Bush-Cheney administration torture regime that we are in many ways still not out of. So the goal of WSRCAT, as we call ourselves, is to end all U.S.-sponsored torture, cruel, inhuman, degrading treatment, indefinite detention, and related goals. We are very grateful to all of the co-sponsors of tonight's event, which include generous financial support and promotion. So our UW co-sponsors include the Center for Human Rights, UW School of Law, the Jackson School of International Studies, the Simpson Center for the Humanities, the Department of Political Science, the Department of Law, Societies, and Justice, the Harry Bridges Center for Labor Studies, the Center for Global Studies, International Human Rights Clinic, and the Sustainable International Development Graduate Program, and the student group Amnesty International at UW. That's quite a UW turnout for sponsoring this event. Very impressive. Also, we have community co-sponsors, Amnesty International of Puget Sound, the ACLU Washington, and the National Religious Campaign Against Torture. So this event is part of a national week of resistance, of action to close Guantanamo. And we are proud to present tonight's talk by Professor Hafetz, and due, as he will say more about, but due to last-minute developments and necessary obligations on a crucially important legal case that the ACLU is involved in, he had to cancel his trip out to Seattle. But we are so grateful, Jonathan, that you have agreed to do this by video conference. So Neil Meltzer, who is the UN Special Rapporteur for Torture, recently said, "A society that's bruised by torture and abuse can only heal when the truth about secret policies and practices is fully disclosed to the public. And," he added, "when full reparation and rehabilitation is granted to the victims." We couldn't agree more. Most of you already know that Guantanamo is not just a prison. It is a system of lawlessness and a hellhole of inhumane treatment, from torture to indefinite detention without trial and to rigged military justice system for the few who will actually face trial. We live in perilous times. Most of us recognize that we are living through a political emergency. Other issues take priority, even in urgency. But we believe that Guantanamo is part of that emergency. Excuse me. Thus, the Washington State Religious Campaign presents this program as part of actions across the nation and even internationally to close Guantanamo. We challenge the ideologies, the justifications, the policies and practices that promote unlawful detention and inhumane treatment in other military prisons as well as Guantanamo. We seek to educate and simultaneously to motivate. Too many of us have become complacent about state crimes increasingly ignored by the public and the media. So we are here to resist arbitrary, unaccountable government, and that we also hold that the continued operation of Guantanamo is part of a dangerous militarism and an opportunistic politics of fear that poses grave threats to democracy and human rights, threats as well to national security and a more peaceful world. So Guantanamo is not only a microcosm, but I believe the essence of a war mentality. And we refuse to allow Guantanamo to continue its continued existence to be normalized by neglect and inattention. Guantanamo is a mockery of justice, and it must be closed. Thank you. Professor Hafetz will be introduced by UW faculty member and Wissercat activist, stalwart, Professor Jamie Mayerfeld. Thank you.
All right, good evening. Thanks everybody for coming out. And I'm very excited about this event. Can you hear me, Jonathan?
I hear you fine.
Excellent, very good. I want to do some additional thank yous. Lots of people made this event possible. I can't name all of them. I'm just going to name a few people in particular. Professor Robert Crawford of the University of Washington, Tacoma, worked heroically and brilliantly to put this event together, and no amount of thank yous will ever be sufficient for what you have done. Thank you, Rob. Alejandra Gonza, the director of the Law School's International Human Rights Clinic, provided crucial support and encouragement facilitating the law school connection and law school sponsorship. Thank you, Alejandra. A giant thank you as well to all the people who enabled this video conference to take place, including Lenny and Russell of the law school's technical support staff, and above all to Stephen Dunn of the political science department. And I also want to thank the engineers, their names unknown to me, who invented the technology that enables us to speak with Jonathan Hafetz thousands of miles away. I want to again thank the Washington State Religious Campaign Against Torture, which took a lead in organizing this event. But our greatest thanks is to our speaker, Jonathan Hafetz. We are sad that Professor Hafetz cannot be in the room with us physically, but we are happy about the reason why. Professor Hafetz recently won a major legal victory on behalf of a U.S. prisoner detained by U.S. forces in Iraq. A few weeks ago, Judge Chutkan of the U.S. District Court in Washington, D.C., ruled that this prisoner, a U.S. citizen, had a right to immediate access to his ACLU lawyers. And Professor Hafetz, who is the lead attorney representing this prisoner, now finds himself in complex, fast-moving negotiations with the U.S. government, and an unreschedulable meeting with U.S. officials today prevented him from flying to Seattle. So thank you, Jonathan, for making the time to speak to us at a particularly hectic and stress-filled time. Professor Hafetz has a dazzling set of academic and professional accomplishments, but I will emphasize in my introduction his enormous contributions to human rights as a scholar and advocate. Following 9/11, the U.S. government engaged in startling and shocking pattern of human rights violations, including torture, indefinite detention, and targeted killings. It was principally human rights lawyers who led resistance to these practices. As the socio-legal scholar Lisa Hajar has argued, if human rights lawyers had not taken up the battle against U.S. torture, the American public would not have mobilized against it. Where the U.S. government has curtailed its abuses, this has been largely owing to the courage, determination, and skill of human rights lawyers, and Jonathan Hafetz has been a leader in this struggle. Professor Hafetz has degrees from Amherst College and Oxford University and is a graduate of Yale Law School. He is a professor of law at Seton Hall Law School and a senior staff attorney with the ACLU Center for Democracy. He has published many major articles in the country's top law reviews and is the author of the editor of two outstanding collections of stories about prisoners in Guantanamo Bay. His book, Habeas Corpus After 9/11, Confronting America's New Global Detention System, won multiple prizes and is taught in several courses at the University of Washington. I see several people here who I know have read his book. It is a miraculously clear, perceptive, thoughtful, and thorough account of the U.S. detention and interrogation regime in the War on Terror. I regard it as the best book on this subject amid very stiff competition. Professor Hafetz has litigated numerous high-profile cases on behalf of individuals held captive in the U.S. War on Terror, in Guantanamo, and elsewhere. Some of these cases have led to landmark judgments against the U.S. government, establishing valuable legal precedent, creating positive turning points for the human rights movement, and providing a life-saving impact for large numbers of detainees. Jonathan Hafetz has provided dedicated long-term representation to several individual detainees, including most recently a U.S. prisoner in Iraq whose name we still have not been told. In his book, Habeas Corpus After 9/11, Hafetz argues that, and I quote, the most significant resistance to extrajudicial detention, military commissions, and abusive interrogations came from the courts. The federal judiciary remained the one branch in which law and facts mattered, even if they did not matter enough, in which the incarceration of human beings was not reduced to sloganeering or partisan gamesmanship, and in which decisions could be rendered with at least some immunity from the fear, hysteria, and irrationality that had so thoroughly infected the public debate over national security, end quote. All this is true. What I would add is that behind the judicial victories that have been achieved lies the remarkable and inspired dedication of Jonathan Hafetz and a relatively small number of legal colleagues. Jonathan Hafetz is a true champion of human rights, and it is an honor to host him this evening. Please join me in welcoming Professor Hafetz.
Thank you so much, Jamie, for such a overly kind introduction. Thank you, and I also want to thank Rob so much for organizing this important and special event, and just to again reiterate personally my deep apologies for not being able to make it out to you in person. I very much wanted to be there, but as was mentioned, just the commitments of emergent commitments in the case did not allow me to leave today and travel out to you. So I'll talk a little bit more about the case later on. But again, just to express my apologies, but also my excitement to be with you through the means that technology made available. Thank you, Alejandra and others for making this possible. And also thank the Washington State Religious Campaign Against Torture for this event and for all they do, for all the important work, in many cases, including critical ACLU cases, like the Mitchell versus Jessen case, which sought to establish accountability for torture. I thank the University of Washington and the various other co-sponsors, and thank you all for being here tonight. It's an honor to be able to talk to you about Guantanamo and the myth of American exceptionalism. So I'll start. It's as you may be aware, it's the 16th anniversary of the opening, essentially, of the prison at Guantanamo. It's amazing that it's and terrifying and horrifying that it's been so long. I mean, I remember having been involved in the Guantanamo litigation sort of early on. Even the first few years, it seemed it would be 3 years, 4 years, 5 years, 10 years, and now it's just mind-boggling that it's 16 years and you still have men there who've been, most of whom have never been charged with a crime, and the few that have were charged in a jerry-rigged system that provides second-class justice. I mean, it's a stain, a permanent stain on the United States, and so it's just every year I'm always stunned, and still now 16 years. So I want to start talking a little bit about what Guantanamo is, and then how we got there, where we are today, and what the future might look like. So as Rob pointed out very presciently in his opening remarks, Guantanamo is a prison, but it's far more than a prison. As Rob said, it's a system. And it's a system of different things, but predominantly, I think, a system of torture and arbitrary detention. Initially, in the early years especially, it was really about, I think, predominantly about interrogation, unlawful interrogation, and torture. Over time, the active torture has faded. You have the legacy of torture, of course, but it's really now today, I think, predominantly a system about indefinite detention. Individuals who've been locked up, ones who are still there, or the ones who've left in the last several years, were locked up for years, more than a decade in many cases, without charge, without real credible evidence, and to me, that's the essence of Guantanamo. It's also a political political dog whistle. It's a form of a way of national security policy. It's become a form of political gamesmanship, and I think that's something that I think has really became true during the Obama administration, as we'll see. It's a form of dehumanization. And it's a symbol. I mean, it is a symbol of lawlessness. So how do we get here? I'm going to talk a little bit about the origins, and then move to kind of the present. I think I like to divide Guantanamo into kind of 3 different periods. The first is the prison outside the law. Then the establishment or the bringing of law to Guantanamo. And then last, we have kind of the state we're in now, which is almost a state of kind of post-law, where we are now, sort of a limbo state. The prison beyond the law, kind of where Guantanamo started, and I think where the most intense, sort of initiated the most intense legal battles. The first prisoners were brought there, of course, in January of 2002. There have been approximately 780 prisoners at Guantanamo over the past 16 years. There are 41 who remain. But during those early years, there were, at most times there were, over 700 prisoners there. Guantanamo, as most of you know, is a U.S.-controlled territory on the eastern end of Cuba. It's a secure naval base that the United States operates essentially as its own fiefdom in Cuba. It obtained Guantanamo through a treaty after the Spanish-American War, and runs it through a series of lease agreements. And though it is formally part of Cuba, it is in all but name U.S. territory, U.S. complete, exclusive, and permanent control over what happens in the 40-mile square base, naval base that is Guantanamo. And so after 9/11, the United States brought prisoners there, some from the theater of conflict in Afghanistan, but also for individuals captured thousands of miles from any battlefield, some from Europe, some from Asia, from the Middle East, and they were all brought to Guantanamo, and they were all given a label called enemy combatant. Now, the United States doesn't use that term anymore, but it's actually, in essence, it really is essentially continues under a different name. And enemy combatant, the United States sought to hold the prisoners there under this status as military prisoners, and they, in a sense, they tried to analogize them to combatants from prior conflicts. POWs, for example, from World War II. At the same time, it used this term deliberately to deny the prisoners any kind of legal protections. So it claimed that because they were enemy combatants and not POWs, the Geneva Conventions, which the United States had helped establish and promulgate, did not apply. And this was the way or the means by which the United States created the possibility of engaging in torture and cruel, human and degrading treatment through the use of this label enemy combatant. So that was one way the United States created this prison beyond the law, and that was kind of the international law side, if you will. The other was the domestic law side. And that had to do with Guantanamo as the sort of nature of Guantanamo as U.S.-controlled territory, but outside of the of sovereign United States. So technically not within the sovereign United States. And so based on that, the United States argued vigorously for years. Until the argument was finally lost after 6 years, that the Constitution, the laws, and then the Constitution of the United States didn't apply. And they, in particular, they argued that habeas corpus, which is the fundamental guarantee of individual liberty that allows prisoners to challenge their detention in court, that habeas corpus didn't apply. First, they argued the habeas statute didn't apply. They lost that in the Supreme Court in 2004. And then in 2008, they argued the habeas corpus constitutional provision didn't apply, the suspension clause. But this was all by way of saying that the prisoners could not access the courts. The Constitution didn't apply. So it was a prison beyond the law under international law through the use of enemy combatants in this idea of a global war on terror, placing people outside the Geneva Convention. And then it was through the use of Guantanamo as this extraterritorial prison as a means of placing individuals outside the Constitution. And so this was part of the creation of a prison beyond the law, and it fed both of those two overarching aspects of the Guantanamo system. Torture, by escaping prohibitions on torture under U.S. international law, and indefinite detention or arbitrary detention by placing people outside of the guarantees of habeas corpus and not enabling individuals to go before a judge and challenge the basis of their detention. And so, just talk a little bit about who were the Guantanamo detainees. Who were these people that were brought to this extraterritorial jail, or this gulag, as Amnesty International called it. They were really a wide range of people. They were from individuals from over 40 different nations. They were ranged in age from individuals in their teens to elderly men. As I said, some they were captured, some captured in or around Afghanistan, others captured far from any battlefield. One client I represented, a individual named Mohammed Jawad, who with the ACLU, we represented him. He was an Afghan youth, about 13, 14 years old, who was accused of throwing a grenade at a tank in Afghanistan. He was brutally tortured, rendered to Bagram, rendered to Guantanamo, subjected to horrific treatment, sleep deprivation, and other torture tactics. And basically, this team, they rendered thousands of miles from home. The U.S. just simply sought to break him. Incredibly, he was charged with a war crime for throwing allegedly throwing this tank at a grenade, even though under clear international law principles, that's not a war crime. In addition, the United States had no evidence that he did anything. The only evidence had been beaten out of him by guards at Bagram and taken under coercion, evidence obtained under coercion by military judges. They failed to obtain a conviction or to be able to use this evidence, even in the jerry-rigged military commission system. And then eventually, a federal judge effectively forced the government to release him, telling them that they had no evidence and their case was full of holes, essentially like Swiss cheese. And he was ultimately released, but not until after years of detention. Another detainee, Mohamedou Salahi, who you know well, and was, I think, the Washington State campaign, and Rob and Jamie and others, who we represented, who was a remarkable individual. He had been captured, taken from Mauritania in Africa, and rendered to Jordan, and then rendered after secret prison to Guantanamo. He was subjected to enhanced interrogation techniques, torture, held for years, and then finally obtained his release. He's now, based on the notes he took in prison, is the author of the Guantanamo Diary, which is a incredible work of recounting his experiences through Guantanamo. And if you haven't read it and you want to learn about what it was like at Guantanamo for individuals, there's no better place than Mohamedou Salahi's book. So these are, in a sense, these are people who managed to get out, but it took years, and they were subjected to horrific treatment. And then they've been barred from obtaining any form of compensation, or even just mere recognition by the courts that their detention was illegal. Some form of apology, if you will, through a court decision. So no accountability. So these are some of the people. Now, the administration claimed that the Bush administration claimed that these individuals were the worst of the worst, to Donald Rumsfeld's phrase. But what we know is that they were essentially picked up without evidence. The United States at the time was dropped leaflets that felt like snowflakes on Guantanamo, on Afghanistan, offering bounty money to anyone who turned someone in, and people would just turn in neighbors they might be having feuds with or people they didn't know just to obtain rewards. And there was no kind of evidence. Even the military hearings, the hearings that the military had used in the past, under the Geneva Convention to sort out who were combatants or prisoners of war and who were innocent civilians. They didn't do that. Instead, they were just taken, rendered, exploited for intelligence value, and then stuck in Guantanamo Bay. Guantanamo was also, it's the most known and notorious prison, but it is not the only one of the post 9/11 prisons. You also have the military detention facilities such as Bagram, where abuses were carried out, and then where the worst abuses were carried out were the CIA black sites in various places in Europe and elsewhere, where the waterboarding and the most horrific interrogation techniques were practiced by the CIA. But they all shared this idea of creating a prison or a network of prisons outside the law through the use of this enemy combatant label. And in fact, many prisoners were moved between these different facilities. For example, all the prisoners who were in CIA, or many of the prisoners who were in CIA black sites, when they were ultimately closed in 2006 as a result of a court decision I'll mention briefly in a second, they were taken to Guantanamo, those detainees. So that's the prison beyond the law. The bringing of law to Guantanamo was started right away. The first lawsuits were initiated by the Center for Constitutional Rights in New York, along with a cadre of death penalty lawyers and a law firm, Sherman and Sterling. The book, The Guantanamo Lawyers, provides that Jamie mentioned that I edited, has more details about this. I won't say too much, but I will say at the time that these groups got involved, it's just important to underscore how sort of raw the wounds and the feelings were from the tragic events, the attacks of 9/11, and how I think courageous it was at that time for these groups to step forward and represent individuals who were simply, there was so much anger and hostility towards, and no one wanted to give them their rights or their day in court. So through a series of habeas corpus lawsuits, some basic law was brought to Guantanamo. These are the cases, some of them are taught now in con law or human rights law or international law of war classes, law schools, well, science and history. These are sort of the landmark cases from this period of time. And there are three of them. I'm not going to go into too much detail about them. Rasul versus Bush, Hamdan versus Rumsfeld, which is 2006, and then the last one, Boumediene versus Bush in 2008. And these three cases from 2004 to 2008 established two main principles. One, that individuals at Guantanamo had a right, ultimately a right under the Constitution to challenge their detention through habeas corpus. So they could bring legal claims and they could have judicial review. They could force the government to provide some evidence and the judge to rule on their case. These were not, it was not the same rights that you would have in a criminal trial, where you get the full protections of the Bill of Rights, but it was some type of hearing that was established, at least for Guantanamo. The United States had fought the application of this right at other prisons, and it's not been extended beyond Guantanamo. The other important legal victory and the bringing of law to Guantanamo was the application of Common Article 3 of the Geneva Conventions. This is the baseline provision that appears in all four Geneva Conventions. It's been labeled by some scholars as a convention in miniature. It's not detailed. It's not like the third Geneva Convention, the POW Convention, which lists out the many rights that POWs have, dealing with mail and contact with family and all other sort of aspects of daily life. But it has two critical provisions in it, Common Article 3. One, it prohibits torture and other forms of abusive treatment, including humiliating and degrading treatment. And it makes those violations of Common Article 3 a war crime. The second aspect is it prohibits trial by sham military commissions that don't provide basic rudimentary fairness. And so those were the two provisions that were established through the litigation. And essentially what they resulted in was detainees being able to challenge their detention through habeas corpus, and then also the obligation on the U.S. to apply Common Article 3 to the global war on terror. Now, it did not stop the global war on terror, right? So which is kind of at the root of everything here. The United States still is engaged in what it describes, or global war on terror as it describes it, a war against Al Qaeda, the Taliban, and associated forces. But it made through the decision that this basic provision of the Geneva Conventions had to be applied to prisoners, and it essentially forced the closing of the CIA black sites and forced the end of at least the worst aspects of the torture regime. Now, there are still significant issues regarding interrogations, but this was resulted ultimately, or was a key part that resulted by the Obama administration in the end of the most flagrant violations or acts of torture. So that's the bringing of some law to Guantanamo. Now, the third stage is this kind of post-law state of politicization, where you see stagnation, entrenchment of indefinite detention, and in many respects, some of the most dehumanizing and dispiriting aspects of Guantanamo. Because by this time, in 2000, by the time President Obama takes office, and certainly before that, there's no question. There's the cat's out of the bag. Guantanamo has been unmasked as a place of lawlessness, a place of torture, and in fact, in the 2008 presidential campaign, both candidates, Barack Obama, John McCain, say we've got to close Guantanamo. It's a stain on the United States. So when Obama takes office in 2009, on his second day in office, he holds a high-profile press conference flanked by senior military and other government officials saying he announces the closure of Guantanamo, that's going to be closed within a year, that he gives a powerful message about the harms Guantanamo's caused to American values, to the rule of law, and that it's those harms vastly outweigh any national security value it might have. That day, he also issues his order officially barring all CIA black sites and requiring that interrogation techniques comply with the Geneva Common Article 3 and the U.S. Army Field Manual. So this is an important day. And just to kind of zoom in on Guantanamo, at this point, it seems people are optimistic that the prison will, in fact, close in the relatively near future. Now, there are real questions among advocates, human rights advocates at the time about, well, what will closure mean? Is it going to just be shutting the prison down and moving the system onshore, creating kind of a Guantanamo North by moving the prisoners to a federal facility, which would be not have addressed the root evil of Guantanamo, or a root evil of indefinite detention, but would essentially be just kind of more of a symbolic measure, or would it be an actual end to the Guantanamo system. That is ending indefinite military detention, ending military commissions, and basically saying, if you are a prisoner at Guantanamo, there are only two options. You're either going to be charged with a crime in federal court, given your full protection of the Constitution, or you're going to be released. Okay. The first year, we see sort of two things happen, and this sets the basically the template for the last nearly 10 years since then. First, President Obama indicates that closure of Guantanamo will not be the end of the Guantanamo system. He says that ideally we would prosecute all individuals at Guantanamo, individuals or suspected terrorists in federal court, but it's not always possible, and there are lawful, legitimate, he said, other options. Military commissions are one, and indefinite detention, forever detention as we call it, this long time law of war detention is an option. So Obama basically gets behind the military commissions and indefinite detention. Now he talks about reforming the military commissions and making them better, and they have gotten somewhat better, but they are still second-class justice. So that's one thing that happens. The second thing is that in terms of the physical closure of the prison, the president does not move in the political space he has in the first months in office, and instead a backlash builds, which basically cuts off the option of even closing the physical prison. And I think there are two data points here in this first year which are critical, and which after which the Republicans smell blood, and they know that they can go after Obama and try to use Guantanamo to make him look weak and use it and prevent closure. One is the case of the Uyghur detainees. These were a group of Muslims from northwestern China who wound up at Guantanamo just completely by mistake. And for these people, at least, the United States admitted they didn't belong at Guantanamo. They said, we agree, these people shouldn't be here. But they could not return them to China because they would be persecuted, tortured, perhaps even killed if they were sent back to China. So rather than doing the thing that human rights law would require, which would be releasing them in the United States, the Obama administration thought that. Let me back up. The Obama administration initially, the Obama administration initially said, we'll try to release some Uyghurs in the United States. And there was a plan to release a few Uyghurs in the United States. There was a Uyghur community in Virginia. It was another elsewhere in Florida, I believe. And this was in the spring of 2009. They were going to try to bring some Uyghurs on. These were people who were not enemies. No one in the government believed they were enemies. They loved America, and they would have. It would have been enormously important, not just to them, but it would have undercut the whole myth of Guantanamo as a place where it was the worst of the worst by showing that these people were, just regular people. They were not the worst of the worst. They were good people, and they should never have been locked up in the first place. But once word leaked, there was a sort of a political outcry, and the Republicans saw they could try to use this to push Obama, and regrettably, President Obama caved in. He elevated other aspects of his agenda in his first year. Didn't want to risk sacrificing those other parts of his agenda, and pulled the plug on bringing the Uyghurs here. The second was later that year, in 2009, the administration was had said they were going to bring Khalid Sheikh Mohammed, the alleged and Sorry, so did the light go off? Can you still see me? I can get it back on.
Everything is great. Oh.
It's okay or no?
Everything's fine.
We're good.
Okay, great. It's an automatic thing. There we go. If I move, it's okay. Khalid Sheikh Mohammed, the alleged mastermind of 9/11, who had been in a secret black site, waterboarded, brought to Guantanamo. The Obama administration was going to put him on trial in federal court in the Southern District of New York, just blocks from where I am and from where the 9/11 attacks were. This is the courthouse, as you may know, where the most many terrorism trials are prosecuted. Well equipped to handle them. We can debate as civil liberties and human rights advocates some of the problems of federal court prosecutions of terrorism suspects, but they are fundamentally fair, they're legitimate, and they're viewed that way. And this was a very important moment. It would have put on the single most important terrorism suspect of this period, probably in United States history, put him on trial in a court where the Bill of Rights would have applied, in a public trial in a federal court, and it would have shown that federal courts could handle these terrorism cases. I think that there's really not much question. He would have been convicted, sentenced, and the case would be over. Due process would have been provided, justice would have been meted out, but what happened was, rather than bringing him to the Southern District of New York when there was political pressure and a backlash about giving terrorism suspects due process or trials in regular courts and non-citizen terrorism suspects to boot, the Obama administration backed down. There was not sufficient planning. There were a bunch of reasons, but ultimately backed down and instead put Khalid Sheikh Mohammed and his co-conspirators back in the military commission system, where I should add now, more than 16 years after the attacks, the alleged mastermind is still in pretrial proceedings. There were years even from a trial date. So when we think about human rights as not just protections of the defendants, but also accountability for people who perpetrate war crimes, and justice for victims, it's just it's a loss from every angle, a complete failure, and largely a political failure. The means were there to do it. So at this point, what happens is then after this first year, when the Republicans see that they can use Guantanamo, politicize Guantanamo, the Congress is emboldened and they start passing restrictions which prevent the president from transferring prisoners to the United States, and also restricting significantly his ability to transfer them to other countries. So Guantanamo becomes politicized. At the same time, the courts begin to walk away. There are many theories about why this may have happened, but the courts, especially the D.C. Circuit in Washington, which has control of all the Guantanamo appeals, habeas appeals from cases in the federal district court there, are taking a very narrow view of habeas rights and really require very little evidence that's not supported in order for the government to be able to prevail and to hold people indefinitely. The Supreme Court turns down several cases and seems to walk away from its kind of supervision that it had been providing of Guantanamo. And so you have this kind of situation where the courts have backed away, not completely, but largely. Congress has made it difficult for the president to close the prison, to transfer prisoners out, and the president himself lets Guantanamo fall off the radar screen until towards the very end of his administration, where he tries to move more prisoners out. So today we're left with 41 detainees, 5 who have been approved for release by all of the different relevant agencies, military, DOD, intelligence, justice, are stuck there, and it's unclear whether they'll get out under Trump. A few who've been convicted by the military commissions, a few others who are waiting prosecution in commissions, and then 23 who are in this state of indefinite law of war detention, which was once sold by the Bush administration to the public as this kind of temporary prisoner of war detention, but it's now become a form of not just indefinite but forever detention without charge. And in fact, the Center for Constitutional Rights today filed a new legal action in court saying that that the courts should now step in, enough is enough, and that they should declare this system invalid. So maybe we'll see some renewal in the courts. Meanwhile, a number of prisoners have simply died at Guantanamo. They've just been there so long. There's also, the cost of Guantanamo are astronomical. To give you an example, it costs about $10 million each prisoner to keep each prisoner at Guantanamo, as opposed to $78,000 each year for federal prisoners. And so now we're something of a crossroads with the Trump administration. As you may know, during the campaign, Donald Trump said many things, but one of them was that we wanted to fill Guantanamo up with bad dudes. So it looks like he was going to sort of try to start filling up, the detention center at Guantanamo with more prisoners, right? The problem wasn't Guantanamo, it was that there weren't enough detainees there. So, and that's still possible. That the Trump administration might. There is that's certainly, I think, the view of Attorney General Sessions, that we should be putting more prisoners there. But there is, fortunately, it's viewed within the executive branch, among DOD, who does not appear to want to get back in the business of long-term detention, as well as state and justice against that. But we'll see where that goes. There was a crudely positive sign that emerged from last month with the terrorist attack in New York by the Saipov, as you may have read about, who used a van to kill a number of people on the west side, a terrible attack. And then there was a time where this high visibility terrorist attack, where this might be the opportunity that the Trump administration would use to bring back enemy combatant detention, send this person to Guantanamo or put him before a military commission. And then for some reason, we don't know, one theory is that Trump happened to be watching Rachel Maddow one night and heard something. He heard that Guantanamo was the last place you want to send someone if you want to convict them or execute them, because there's it's molasses there. And so he said no, and the defendant is now in federal court. So we'll see if that trend continues. So that's one sort of direction it could go. The other is, even if new prisoners are not brought there, we still have the current situation that I mentioned, where you have 40 plus detainees who there seems at this point not a lot of hope for, even the ones that have been cleared for release. And so you have this kind of continuation by attrition, which will surely be slower, if nothing else, under the Trump administration. And so we could be talking, what will we be next year at 17 or 18 or 19 years, where this prison becomes a lifetime prison, and what the sort of entrenching Guantanamo's legacy. And so this is, and the fate for the men who are there. So those are two roads. Then the hope is that the courts will re-engage. I think there's really very little prospect at this point for Congress to get behind some rights-based approach to Guantanamo, but perhaps the courts will re-engage now, particularly when there's a individual in the executive office does not look like he's even remotely trying to solve the problem of Guantanamo, and the courts will you do something and maybe there will be some movement there. So I want to make sure I leave time for questions, but I do want to just transition quickly to the recent case, the one that's been keeping me so busy that I'm unfortunately preventing me from being with you tonight, the case of John Doe versus Mattis, or was formerly ACLU versus Mattis. Because this is it's not a Guantanamo case yet, but it is part of this larger system. And so I don't know if people know about it. I'll just kind of give you a brief recap of the case and why it's so important. So in the middle of September, there were reports in the Daily Beast that there was an American citizen who was being detained by the U.S. military in Iraq, that this individual had surrendered to Syrian Democratic Forces in Syria and was being held in Iraq as an enemy combatant. And the United States, well, they continued the Guantanamo detentions, had not detained a U.S. citizen as an enemy combatant in over a decade. So there had only been 2 U.S. citizens who were held one in the United States as enemy combatants. So there was a sense that this was looked like possibly a startling revival of enemy combatant detentions being done against a U.S. citizen. Now, as we know, under human rights law, citizenship doesn't matter. The basic rights against illegal detention, abuse of treatment apply equally. But under the Constitution and the case law of the Supreme Court and the decisions, citizens have greater protections, particularly where they're outside the United States. So this was very concerning that looked like they were holding an American citizen as an enemy combatant. So we wrote to Attorney General Sessions and Secretary of Defense Mattis. The ACLU did, expressing our concern about this, explaining why holding a U.S. citizen in secret detention without habeas corpus or due process or charge was illegal, and demanding be provided access. You'll be amazed to hear we did not receive a response to our letter, and so we then filed a petition in federal court on this person's behalf. And we proceeded because we did not know the person's name, and the United States was not allowing us to speak with him. We filed this as what's called a next friend petition, which allows an individual organization to seek relief on behalf of a prisoner where that prisoner is held incommunicado, doesn't have access to the courts himself, if this person didn't, and where the group is dedicated to that individual's best interests. Now, normally, in the Guantanamo cases, and then the U.S. citizen enemy combatant cases from right after 9/11, these also were next friend cases. But in many of those cases, the families knew who the detainees were, and they were the next friends, so they had a close relationship. As the ACLU were a historic respected rights organization, but we don't we had no connection to the detainee. So the government argued, they tried to have the case thrown out, saying we didn't have standing, that because we had no relationship to the detainee. And our response was, that's true, but he's not been able to speak to anyone, as far as we know, and has no means of accessing the court himself. So at a minimum, the court should allow us to speak with him to find out if he wants to challenge his detention by habeas corpus, and if he wants the ACLU or some other lawyer to represent him. Ultimately, he's the prisoner, it's his life, it's his choice, but the government was not letting him exercise that choice and was not allowing anyone to do that. We filed that petition in October, and then the case proceeded with not a lot going on, although there were a couple of important developments, the most important of which was a story in the Washington Post quoting unnamed U.S. officials, basically saying that while he was in detention, he'd been interrogated first by the intelligence agencies just to, not for evidence of a crime, but to find out what he knew. And then at some point after that, the government brought in its so-called clean team, FBI agents, individuals who come in a separate interrogation to try to build a criminal case. And when they do that, they read the suspect, as the Constitution requires, they read the suspect his Miranda rights. And when they read him his Miranda rights, I told him about his right to remain silent and his right to a lawyer, he said, I want a lawyer. And so the Washington Post story reported this, said that when asked, he said, I want to have that when asked when read his Miranda rights, said he wanted a lawyer. So we said this, we presented this to the judge and said, look, the government's saying, we don't know what his wishes are. Maybe we have no relationship to the detainee. Maybe he doesn't want to, proceed with the habeas. But we don't know. We said, well, you're right. We haven't spoken to him, but here's this evidence of this, article saying given the one time he was asked whether he wanted to have a lawyer, he said, I want a lawyer. And so at least we should be able to talk to him once to confirm if that's true. And the court held a hearing. They asked the government attorney, is this accurate? I'm not going to just take what I read from an unnamed source in the Washington Post as gospel, but I want to know, is this true or not? And the government did not provide an answer that day, but the judge required them to do so by that afternoon, and they filed something saying, yes, it was true. He asked for a lawyer when he was read his Miranda rights. So we thought that would be sufficient, but the government then continued to argue and said, well, he wants a lawyer for Miranda interrogation, but that's different than wanting a lawyer for habeas corpus, which is a very kind of arcane distinction. And that if you're a regular reader of Just Security or Lawfare or the other blogs, you might know that, but your average person would have no idea. They didn't want a lawyer, they might want a lawyer. And so the judge, eventually held another hearing, and then just a couple weeks ago, just before Christmas, rejected the government's arguments and said that we had standing, next friend standing, because the detainee was inaccessible, and because from the evidence we were dedicated to his best interest, and ordered the government to provide immediate, unmonitored access to this American citizen detainee to find out, does he want to proceed with the habeas action that's been filed on his behalf, and if so, does he want the ACLU or some other attorney to represent him? We then were given access to the detainee after we spoke with him about a week ago in response to the court's order, and I can't go into detail about the conversation. I've said this, the conversation. We spoke in English, and he expressed very clearly that he wanted to challenge his detention in habeas, and he wanted a lawyer, and he wanted the ACLU to represent him. So we informed the court of this. The court, saying that he wanted to go forward, and so essentially that our argument was, well, now let's go forward, and basically taking the case presents back to the start, where the government will have to come forward with evidence to justify his detention. The other piece is that we also have asked the court to continue the restriction that the court put initially after the judge issued her order in December, right around Christmas, the restriction on the detainee's transfer from U.S. custody while until his habeas case was decided. Because of the concern that he could be rendered lawlessly to another country. That's happened in the past, of course, and raising concerns about a host of concerns about from lawless transfers. And so we are asked the judge to extend that restriction on transfer so she could decide if he was being held illegally. The government has opposed that, and so that's an issue that the court's going to decide next. And then the government will also have to come forward with evidence to justify his detention. They asked for, under the habeas statute, your detention, the government's supposed to come forward with evidence in 3 days, a justification in 3 days, or at the most 20 days. They have asked for 6 weeks, saying they now need to gather evidence, which suggests a policy of detain first, gather evidence later. Very troubling policy. The judges to rule on that as well. But that's where the case stands. So moving quickly, lots of developments and aspects to it. And so it's a case where it's a case that kind of is bringing us back to some of these issues around Guantanamo and its legacy of enemy combatant detentions. Can you hold someone without charge, including a U.S. citizen without charge as a combatant in the war on terror? Can you bar his access to habeas corpus? Can you transfer this person without any kind of judicial review? And so we're, in a sense, it feels for me like a wise non-legal scholar once said, the deja vu all over again, refighting these battles. So I'll just say, just to conclude, and because I do want to hear your thoughts and questions, about American exceptionalism, and I think there are things to be proud about, and that have emerged as positive from this. About the courts have checked the government in some circumstances, not hard enough or forcefully enough, not often enough, but they have done that. And we can see, in fact, some of the landmark decisions from Guantanamo now being cited, for example, in the challenge to the Muslim ban, the travel ban, as checks on the executive's authority in the area of national security. That's positive. But I think there are real concerns about American exceptionalism being defined as being a paragon of human rights, due process, and the rule of law. And to me, these often get wrapped up in complex legal doctrines and talk about decision cases, but they're really very basic. And I think they'd be understandable to someone, to a child. One is, if I've done something wrong, charge me with a crime, right? Put me on trial, charge me, right? And that has that basic right, that basic sort of principle has been eroded by Guantanamo. Another is if you did something bad to me, you should be held accountable for it. And that has two dimensions. I should be compensated, right? If I was tortured, and he was tortured, they should be compensated. But the courts, with a notable recent exception, the Mitchell and Jessen case, litigated out in the Eastern District of Washington, which resulted in a settlement. The other cases have been thrown out. The judge refused to throw that case out, that judge. But every other judge has thrown these cases out. And it's not because the judges have found that torture didn't happen or that the allegations were false. They've said it's state secrets or it's too sensitive a political topic. We have to wait for Congress to make a law. So that's one aspect, the lack of accountability for the victims. The other is lack of accountability for the people who perpetrated war crimes, right? None of the senior officials, those most responsible for instituting the torture program, practice of torture, have been held responsible. Now, advocates are still trying to do that in the U.S., but as well as in international forum. And the International Criminal Court has recently opened an investigation into in Afghanistan, including possible war crimes by U.S. there. So perhaps international justice will bring us closer to that ideal of that no one is above the law, right? But that's another thing. It seems very clear that that's not true, right? There are people who are above the law. These are sort of basic ideals of American exceptionalism that suggest that it's a very complicated concept, and rather than being this beacon of human rights, the United States human rights record and commitment to human rights is deeply problematic. And so I think Guantanamo is a microcosm of that. I would love to hear your questions, Guantanamo remains a critical for the individuals there, and is a test of America's commitment to the rule of law.
Thank you very much. That was really tremendous. I don't know. I mean, you spoke a very long time and have kept our attention and told us a huge amount of information about the history of Guantanamo. I mean, that was a real tour de force. And so if people walked into this class, into this room, and didn't understand some of the basic issues, now I think they really understand. And you've tied it together with some made some big claims about where we're going and about how we should think about U.S. exceptionalism. And I think people will have lots of questions, maybe about where we're going from here, or how specific questions about Guantanamo, maybe questions about your own experience litigating these cases, maybe some questions about this case, to the extent that this new case about the prisoner in Iraq, to the extent that you can and talk about it. So I think what we will do is have people raise their hand if they have a question. And we might, if you are far away, we might bring the microphone to you just to make sure that Professor Hafetz can hear you all the way in the back of the room. So I invite questions and comments from people. Why not you in the back? We'll start with you.
Yeah. Why hasn't the fact that Congress never declared the global war on terror or any war at all since 1945, why has that not been more strongly litigated?
Great question. So I think the sort of the congressional authorization has been an important issue. As I see it, it's in terms of the declaration, the United States, as you say, does does not really wage war anymore through declaration of war. And this kind of predates, this really predates 9/11. It's Congress has done it through other forms of authorization. So, I think that the understanding is as long as Congress has authorized force, that has been deemed sufficient. It doesn't energize the same powers, all the powers the declaration of war would, but that has been deemed, sufficient by courts. I mean, to me, the bigger question is the sufficiency of the congressional authorization itself, right? So Congress, in 2001, just days after the 9/11 attacks, authorized the use of military force against nations, persons, and organizations responsible for the 9/11 attacks and those who harbored them, right? And so what the government read into that was, well, that means Al-Qaeda, and that means the Taliban. However, they took this very brief, authorization and created this entire edifice of a global war on terror around it. So it was an authority not just to detain individuals fighting, in the battlefield, in the theater of combat in Afghanistan, right, where the United States invaded after 9/11, but people picked up all over the world, including two individuals picked up in the United States, one of whom, Jose Padilla, the other, Ali Al-Mari, who I represented previously. And so that's one big problem. The other is, which we're confronted today, and this is an issue in the John Doe case I mentioned a moment ago, the current case, which is that the as you may be aware, the United States has been, waging war now against ISIS under the same 2001 force authorization, which was directed at the 9/11 attacks, right? And as well as the 2002 force authorization, which was directed at removing Saddam Hussein from power. So to me, there are individuals in Congress on both sides of the aisle who have recognized this problem, saying, well, okay, whatever we've authorized against Al-Qaeda, assuming that war is continuing, I mean, there's no authorization against ISIS, a group that didn't even exist at the time, and that's publicly opposed to Al-Qaeda. So that's a big issue. So I think there's been, kind of finish on your question, there's been a real abdication of Congress's role as a coordinate branch in either declaring war or in authorizing the use of force.
Thank you. All right.
Follow up.
Yeah. Okay. The justification that I recall that the Bush administration had given for instituting military commissions was based on historical uses during times of declared war, such as World War II. So would you see an argument there that lacking that formality, which historically was a very serious formality, that extreme measures like military commissions should have been overruled all along?
Yeah, I think it would have. I think at least before 2006, the first military commissions, when President Bush created them just unilaterally by executive order, might have been on a little bit stronger ground if there had been declared war. But even then, I would say those commissions still would need to be authorized by Congress and be consistent with the Constitution. And the commissions, as the Supreme Court found in 2006, in the Hamdan case, those commissions were not authorized by Congress because Congress had said, to the extent you have commissions during, at any point, whether it's declared war or some war that's fought under a force authorization, they have to be consistent with the Uniform Code of Military Justice and with the Geneva Conventions, and these weren't. Since 2006, Congress there's been a statute that Congress enacted after the Hamdan decision expressly authorizing military commissions. So it's been, so there's sufficient legislative authorization at this point. The real question in the commissions is what are the constitutional limits on the commissions, and can they try offenses that aren't actually war crimes, like conspiracy, which all the international criminal tribunals say is not a war crime. Can they try those as war crimes? So those, to me, the bigger issue now is not so much Congress, because Congress has authorized commissions. It's the limits of the Constitution on those commissions.
Regarding the military commissions, if the brigadier general who's running the defense team down there is found in contempt, what, if any, recourse might he have in civilian courts?
Could you someone repeat the question? That question I didn't catch.
We're going to bring him the microphone.
Oh, okay, great.
What part is the Oh, okay. If regarding the military commissions, if the brigadier general who's running the defense team down there is found in contempt, would he have any recourse in civilian courts?
Yes, it's my understanding he's been found in contempt. This is a question which probably take a while to fully unpack, but the recent studies, if people aren't aware, there's been a issue which just shows how bad and absurd the military commissions are. There's one case involving a detainee named Nashiri, capital case, I should add. It's a death penalty case, his lawyers have had to feel they cannot continue in this case because to do so would violate their ethical obligations, because due to the overclassification, they are not able to share information with their client or even tell him that they can share certain information to him. And they said, basically, as a lawyer, a licensed lawyer, attorney, I am not able to represent you consistent with my professional obligations. And so they went to the chief defense counsel in the military commissions, and he said he agreed, he relieved them from the case. The military judge then basically found the chief defense counsel in contempt, claiming that only he could relieve the defense counsel, even though the commission law suggests the opposite. And so he was in contempt. He was in basically, I think, house arrest for a couple of days, and then was relieved of the sort of incarceration aspect. There's a fine that was imposed, but the contempt finding is still intact, and there's an appeal, a habeas corpus challenge in federal district court now to this contempt finding. But this shows how problematic the military commissions are when the lawyers feel they cannot go forward ethically, and meanwhile the judge in the case, the military judge, is proceeding in a capital trial without learned defense counsel. There's in a death penalty case, you have to have death penalty lawyers who have experience in those cases. Instead, it's a attorney who's a military attorney who's one person left, who's very good and dedicated, but is maybe a year or two. I might get the dates wrong, so forgive me if I'm misstating this. A couple of years out of law school, or never tried a capital case, and he's just kind of holding down my fort. And so this is the idea that they're proceeding in this death penalty case is just outrageous. And if you sort of look at the military commissions in comparative context with other war crimes tribunals, the International Criminal Court or the former International Criminal Tribunal for Yugoslavia, it's like Venus and Mars. I mean, this is not a court that meets international standards. The military commissions.
Go ahead. First of all, I really appreciate your work. And I'm wondering if you feel that other parts of the ACLU may be making your work harder by joining with the 1% in the Citizens United case, therefore allowing unlimited amounts of corporate cash into our elections, allowing unqualified billionaires to get control of our government, eventually our courts. And I'm wondering if you feel that ACLU position is making your work harder.
So I'm not sure of the best way, or I can really, sort of, ask them here and sort of at the ACLU speaking now. So I may sort of not give you the sort of answer you're looking for, or can answer. I think. I don't feel that the work that we do, I think we've been able to fully do the work that, you do at the ACLU. It's sort of not, I don't know how to say too much, but I don't mean not to answer your question on that. But I don't want to sort of misspeak for the organization. I'll say that not every not every one of these always personal matters always 100%. People have different perspectives on issues.
All right.
Sorry about that. So.
Fine. All right. That's a good question. Alejandra. Go ahead, Tim.
Thank you. So you mentioned the ICC's investigation in Afghanistan. Apart from relying on American federal courts and other American stakeholders like the ACLU, can we turn to the ICC or any other international legal institutions to directly prevail justice in the case of Guantanamo?
I got part of that. If someone could just repeat. I didn't get the whole question.
So you mentioned the ICC's investigation on Afghanistan. Apart from relying on the American federal courts and other American stakeholders like the ACLU, can we turn to the ICC or any other international legal institutions to directly prevail justice in the case of Guantanamo?
Yeah, it's a great question. I think the answer is yes. I mean, one of the, I think, yes and no. I think yes to the extent that one of the things that human rights advocates have done, very successfully is to use and take advantage of other fora to enforce human rights protections and obtain accountability. The most successful suits on accountability for torture have been in the European Court of Human Rights, where there have been cases, victims of extraordinary rendition and CIA detention have successfully sued governments that cooperated with the United States, in the secret rendition program, right? That kind of program could not have existed without the cooperation of other countries. The United States needed, the help in apprehending detainees and also needed places to house these secret detention facilities. And in a couple of cases, the case of Al-Masri, Macedonia was held civilly liable before the European Court of Human Rights. Cases also against Poland in the European Court of Human Rights. I think there's a case against another country pending, but these are the only cases where there's been any kind of accountability for CIA torture and detention. Now, the limitation is that those cases don't directly hold responsible the U.S. officials who were the primary agents or actors in setting up the CIA detention program. But they do provide some accountability for victims. They do establish or strengthen human rights norms. And I think as a practical matter, they increase the cost of trying to do this again for the U.S. They make it more difficult to do again. I think it would be very difficult for the United States to set up secret black sites in Europe after the European Court of Human Rights rulings. Now, so another possibility is they might find, they find out the sort of least common denominator and go to countries, allies in the Middle East or Africa, East Africa, or elsewhere, and use sort of run detention operations out of those countries. But I think these decisions have had an important impact, and so I think it's very important for advocates to use other courts, international courts, regional courts, to establish norms and forms of accountability.
Thank you.
Thank you. We still have more questions, so if you can keep going.
Yeah, great. Yeah.
Alejandro, why don't
You should be able to be heard.
I think we can hear you if you're in the front.
No, it's better with this. I do that in the class, so otherwise it's the repeating. Thank you. Well, that was a great question, Tim. Thank you for asking. I would add also the importance of the Inter-American Human Rights Commission and the work. You can check on the work. They have done reports on Guantanamo. They have issued decisions on the merits of cases against the United States. And also they granted precautionary measures protecting people in Guantanamo. So it is a tool of advocacy, gaining awareness, and getting victims some kind of redress that comes for the pronunciation of international bodies. Even though it's not binding for the United States, they have been public hearings about it, and it's for years they've been deciding that. But I have a question for you that is more out of curiosity, that I have no idea. How is the gender issue in Guantanamo? Have the U.S., through the history of Guantanamo, been sending women there, and how is the situation if they did, and how many, and why those cases are not that, if any, so public, right? We heard a lot of cases that are men. So that question is the one that I have for you.
Yeah, so I think, Guantanamo is all only men. Yeah. So the gender, only men have been brought to Guantanamo, so the gender issues are, the way they come up is sometimes in, with the relations between the male detainee clients and the, and female attorneys. Yeah. And so there have been some, that's come up, and it really varies. I think it depends on kind of a lot on the experiences of the individuals and the different detainees. But women have gone down. Many women have represented detainees, and to some extent they, they'll make adaptations out of kind of cultural respect in terms of their presentation and things like that, but it's kind of, there's, I think there are, I don't know as much about it, but there are, I think one of the, kind of a closer example of your question is these prosecutions, criminal prosecutions, including in Europe of women who've been, accused of being sort of, foreign fighters. And how those, cases have played out. And so that's sort of another area where they pile up. But at least Guantanamo, it's only been men. Oh, sorry, the other dynamic, the other gender issue which I should mention is, of course, the way in which, gender was used against prisoners by, using female guards as a sexual form of humiliation through a forms of sexual humiliation for male detainees during this. So that was one of the tactics that was used to torture or cruel and degrading treatment tactics that were used by female guards to make male detainees feel uncomfortable and violate their kind of religious beliefs, and humiliate them. So that's sort of I guess the positive side is that sort of women detainees are going to come able to represent it. The negative side is the way the female guards and male prisoners.
So my follow-up with that is, so when women is involved in the same type of activities that men are, that are sent to Guantanamo, what are they doing with them?
Yeah, I don't know at the time. I mean, I'm not sure at the time. It's a good question. I don't know. Like most of the people at Guantanamo were captured shortly after 9/11 in Afghanistan. I don't know, but there were a lot of what happened to any women that were picked up then. But I think the example where it seems, from my understanding, it's really happening is with the current sort of foreign fighters for ISIS, where there are a number of women, and some have been how they're treated if they're brought back or prosecuted in Europe. But at Guantanamo, I don't know that there were that the U.S. captured many, if any, female detainees. If they did, they didn't bring them to Guantanamo. And actually, it's really interesting if that were true, if there were some why they didn't do it. But there weren't. So I guess the last thing I would say is, if the United States did try to. If the Trump administration did try to revive Guantanamo and start bringing people there, then it might come up with, if there were, female foreign fighters or alleged female foreign fighters, what would happen then if they started bringing them there? So, and who knows what this administration would do? So I don't know. It's something to keep an eye out for or watch on.
Thank you.
There's some other people with questions. So I see a few more questions. I'll take that one first in the back. Thank you. We're going to bring the microphone to the mic to the other side of the back.
Can you hear me? Oh, hey. My question is, were the enhanced interrogation techniques ever proven to be valuable? I mean, presumably, these people are being tortured for intelligence, but, I imagine if, you're being waterboarded, you're willing to say almost anything to get out of that. So it just seems, just from a purely pragmatic standpoint, like, how can you defend that practice? Because the intelligence would just seem unreliable to me.
Yeah, so I think the most powerful evidence that's been compiled that torture doesn't work, these techniques don't produce valuable intelligence, is the Senate Intelligence Committee's report about the CIA detention, interrogation, rendition program, which this is a I think 6,000-page report. Regrettably, only the executive summary has been made public, but it's about itself is several hundred pages, and it is sort of creates a very powerful record that these techniques don't work. I think most professional interrogators, all professional interrogators, people who really do this for a living, would tell you they don't work, and that there are far more effective ways to get information from individuals. And this was not, these techniques were not, it wasn't professional interrogators or experienced interrogators who came up with them. It was people who didn't know what they were doing. It was like sort of amateur hour. And these people were allowed to come up with these techniques, essentially by reverse engineering a group of techniques that were used to train U.S. soldiers if they were captured by enemy forces on how they resist techniques. They were reverse engineered and used by the U.S. to, as part of the torture program. So they don't. So I think there's really strong evidence that they don't work. It's not that I don't think I could ever say that no valuable intelligence could ever be produced, but they don't generally work, and they are not an effective means, and they create all other kinds of problems. But I also want to say, I think it's, there's value in making this pragmatic point, but there's also kind of a risk, because it makes torture a matter of kind of, it opens it up to, well, if it works, then maybe we can use it, whereas torture is illegal, it's immoral, and should never occur. And so I think that's, from my point of view, it can be helpful to talk, to reinforce use the evidence, the evidence that torture doesn't work, to reinforce the legal and moral prohibition, but that's the starting point. Is simply that it's just torture should not be used, full stop, and not to sort of open up the permissibility of torture to its efficacy. And I'd say one of the positive things is there does seem to be within the military and within the intelligence agencies a recognition of that the torture program did not work, was very harmful to the United States, very harmful to the agencies, and I think there are a lot of individuals within those institutions that would resist bringing it back. So when Trump talked about, during the campaign, we need to bring back torture, I'm going to do it, I'll do what it takes. They're sort of, there were the courts as a potential check, but actually I think the real check was sort of within the military intelligence agency saying no, and the pushback on that. It's not to say it won't happen, depending on who's who might end up running these agencies at any point in time. But I do think there's recognition within the government too, or concern within the government about reviving the torture program.
Great. Yeah, that important question, important answer. Okay. Go ahead, Megan.
Hey, Jamie.
Will you wait for us to bring the mic to you, and you want to maybe move over to the chair so we can see you?
Oh, okay. All right. Hi. My name is Megan Francis. Really thank you so much for taking the time to talk to us today. I teach your book. I'm a professor of political science to introduce students in my big intro class as well as in my civil liberties class, because I think that in terms of, especially this generation right now, many people call them the 9/11 generation. They've dealt with what is going on right now is at some level kind of a normality, and it's very much normalized. So I think it's very important that they contend with so many of these issues. My question is, I have like two questions. I'm going to slightly cheat here. One, so much of what Guantanamo is, especially in terms of the torture program, is meant in terms of not just in terms of physical harm. We know so much of it is also psychological harm. So I'm curious in terms of in the ways in which it dehumanizes people. From your experience with the clients that you work with, I'm wondering if you could say a little bit about the ways in which your clients, in kind of these horrible circumstances, find ways to resist and ways to hold on to their humanity. So that's one question. And the other question is about, I have been fascinated and horrified by this Doe v. Mattis case. And I'm curious if you could say a little bit more about that. I had thought that at least kind of the way that in which I teach my students, that the question about U.S. citizen detainees' access to counsel was closed. Like I thought, but it's not apparently. So I was wondering, is this something that we're going to see a lot more, that we take them to different countries and we hold them in secret? So that's it. Again, thanks so much for talking to us today.
Thank you. Great questions on the. So I'll do the sort of psychological aspect for sure. I mean, I've seen, the harm of the mistreatment that's caused. And I think, to me, certainly the physical abuse can causes harm, but the mental harm as well as physical harm. But and that's recognized, and then sort of people can easily grasp that, right? But it's the indefiniteness, the length and the indefiniteness of the detention that in some ways is psychologically the hardest, right? And I sort of represented individuals who spend years in this sort of indefinite detention, so it's not just being like charged with a crime and so you get a full trial with, proof beyond a reasonable doubt and all the Bill of Rights protections. It's you also get some kind of closure and time restricted. So if you're convicted, you will be sentenced, right? And that idea is very important. One of the individuals I represented, Ali Al-Mari, who was one of the two U.S. enemy combatants held in the U.S., was one of the three held in the U.S., but only one of the two was arrested here. Anyway, he was held at the Naval Brig in South Carolina for 5.5 years in indefinite detention. We took the case all the way to the Supreme Court, and eventually he was transferred to civilian custody and charged with a crime. But that period of indefinite detention was so hard when people just don't know. And detainees cope with it in different ways. For Mr. Al-Mari, it was really just he had sort of a lot was through religion, and that was sort of a source of strength for him. But the lawyer, for those detainees, lawyers, in addition to fighting the legal case, become a critical point of human contact to maintain keep the detainee, with some form of human contact that's not his captors, and help him through this period of time. And so that's kind of a role that a lot of the detainee lawyers have played. Even now at Guantanamo, where not much is happening in the court cases, but the lawyers are they still go down because it's so imperative for them to see these clients in isolation. Other detainees don't do as well. They suffer, real harm from the mistreatment and from the indefinite, prolonged nature of the detention. I mean, just to be locked up for 16 years, as these individuals have, and never know when never being told you committed a crime, you're going to be sentenced for this much time. It's just a devastating. It's devastating psychologically. And so on the Doe versus Mattis case, it's a very good question. We thought the same thing, that we said, isn't this issue of counsel access settled? Like, why are we fighting this again? So the issue I talked a little bit more about in Doe was the next friend standing issue, which was a little bit different. But the government had a second argument, which was, even if we had standing, right? Even if we were, we had come in as this detainee's, his mother and father, or his, asked us to come in, and we were therefore, not some stranger to him. The government said that counsel access was not right. That it had that it was not long enough yet. And they said this in the beginning, after a couple months, and they said this after 3 months, and to us, this was astounding. They basically said that we've called him an enemy combatant, but we haven't determined his final disposition yet. And so we went back and we looked at these early counsel access cases that you kind of indirectly referenced. And interestingly, one of the strongest cases was the Jose Padilla case. This was the enemy combatant that was held in the Naval Brig in South Carolina. And he was accused, not of being some kind of foot soldier. He was accused of being, coming to the United States and actually exploding. They thought he was going to explode like a radioactive bomb. A real terrorism plot that they foiled. And even still, the judge in that case ordered access by his lawyers, even though the government said if you give access to the lawyer, it will interfere with our interrogation, it will interfere with our ability to induce a sense of dependency in the prisoner. It will imperil his safety by preventing us from getting valid information. And the judge still said he has the chance to be able to speak to his lawyers through habeas corpus. And that judge, in the case, was not the judge you would immediately think of. It was Michael Mukasey, who later became Attorney General under Bush. So it was this, and he wrote one of the strongest opinions on counsel access. So we were kind of flabbergasted that the government was kind of trying to refight the same battle that they lost and saying, you don't have a right to a lawyer if you're held as an enemy combatant.
Great. Maybe we can take one or two more questions. One more question. All right. All right. One more question. And thank you for sticking around and asking.
It's my pleasure. These are great. It's great to speak to you. So yeah, please.
All right. Here we go.
So regarding the John Doe case as well, my question is, I guess, framed around the back and forth that Ben Wittes and Stefan Vladeck had about when an anonymous detention becomes worrying. And I'm just wondering about your take. How is it that people should know when to be worried about these sort of issues?
So you broke up a little bit. Could someone I got anonymous petition.
My question then is about your take on the debate they had, if you're familiar with it, and then also how people like us in the audience should know when to be worried about these various national security issues.
Okay, let me try that. I hope I heard about it. Just how lay people should be why you should be worried about it.
Or how we should be able to tell when one of these cases is broaching kind of new worrying territory, or when it's just legal arcana, or how can we sift through which issues matter, frankly?
Yeah. Okay. Let me try. Well, one issue which is that's really troubling, I think. I hope this is responsive. Is what if the Daily Beast had not published the article it published, right? Like, what if this had never become a case because we never knew? But the only reason we know, we at the ACLU and other advocates and the public even knew about this was because a journalist found out. Otherwise, you would have, secret detention. We wouldn't even know. The only reason we were even able to file a habeas case is because we found out that someone was being detained. And hopefully we've created a precedent that if this happens again, that there will be, groups to be able to get access to see if the detainees want lawyers. So, I think so that issue matters. You're asking, I think, right, about what other issues that matter. I think so. Access to counsel, access to habeas rights matter. Indefinite detention matters, and so was that? I'm sorry, I'm not sure that I wasn't sure I got all your question. Was that basically, or was there anything else you were asking? You go ahead, please. I want to make sure I answer it. So,
well, I guess just broadly, my question is, I suppose there's probably a lot of lawyers in this room, but I'm not a lawyer. I don't have legal knowledge, and so I guess I'm just wondering, is there kind of a method you would recommend for trying to figure out when a case is broaching new ground, when it really is something serious, and when it's kind of just procedural or
all right. Well, to me, I love to pick on the procedure point because the issue. The issue in the John Doe case that we litigated for the last 3 months was a procedural issue, right? It's this issue of next friend standing. It's not an area of law that necessarily lends itself to lofty principles, but at the heart of this procedural issue, right, was a fundamental due process issue. right? Which was that if we could not serve as next strength, if we didn't have standing, right? So this, technical standing question, then this person would have no access to the courts. He would have unchecked executive detention. And so sometimes you have kind of a procedural issue that is really behind it is a major, constitutional question. Because if you can't, if there's no procedural avenue, or if the procedural access is foreclosed, they're not going to be able to challenge his detention. And then a big question in this case that people will, if you read some of the blogs and kind of talk about this in the background, if it goes to the merits, does the force authorization, the EUMF that we were talking about before, does it authorize military force against ISIS? Right? That's the question the court would ultimately have to reach. And yet that the ability of the court to reach that question, lying behind that question is basically not just detention, but all the drone strikes against, the ISIS, the domestic legal authority for the drone program against ISIS. What will happen, I don't know in this case, but the mere ability for that question to get to a court was really, in a sense, tied up in this procedural question of next strength standing. So the procedure and substance interact in important ways often.
Jonathan, I want to thank you on behalf of everyone for an extraordinarily informative talk. Thank you, everybody.
Thank you all.
We're honored you spent these 2 hours with us, especially after such a long day going from the Pentagon back to New York. You do extraordinarily important work. We will continue to follow as best we can the ACLU and your work in this case and in future cases. Thank you again.
Thank you.
Thank you. Thank you. Bye, everyone. Thanks so much.
Thank you.